Good afternoon, everyone. I'm Amy Rizzo, and I'm the marketing manager here at Kelleher and Holland. Thanks for joining us today for the September episode of our monthly Lunch and Learn webinars. Today's topic is Digesting the Illinois Paid Leave for All Workers Act, or what we will refer to as PLAWA, which will touch on some recent changes in the Illinois law surrounding mandated paid leave for employees. Before we get started, if you have a question at any time during the webinar, please type it in the Q&A question box that is located in your Zoom control panel, and we will address following the presentation today. Our two presenters are from our employment law group, Andy Bowling and Madeline Kelleher. So a quick lunch-related question for our panelists. What's your favorite healthy snack?
I'll go first. I love fresh fruits. It's just something I will always love.
That's a really hard question, but I would say on the healthy side, probably almonds, smoked almonds.
Sounds good to me. So let's get started. Madeline, earlier this year in March 2023, Governor Pritzker signed the Paid Leave for All Workers Act. So let's start off with the purpose of this act and what changes it brings.
Thanks, Amy. So the Paid Leave for All Workers Act is the first statewide paid leave law in Illinois, mandating paid leave for all employees. The new act, including the new paid leave accrual requirements, say that 10 times fast, will take effect on January 1st, 2024, which means that prior to January 1st, 2024, all employers in Illinois should review their current policies and procedures for compliance and make sure that they take the necessary actions that must be done in 2023 before the act actually takes effect. So the act's going to be requiring every Illinois employer provide each of their employees up to 40 hours of paid leave for every 12-month period. And this will be at an accrual rate of 1 hour of paid leave for every 40 hours worked. The employees may use this paid leave for any reason of their choosing, which means any reason for their absence. It could include illness, a vacation, care of a family member, anything. And so while on this paid leave, employees must be paid at their normal hourly rate of pay. And the question comes, what about those employees that get tips or are on commission? And those who are regularly paid with gratuities or commissions as part of their pay must be paid at least the minimum wage in their jurisdiction of employment.
So does this decision, Madeline, apply to all employers?
Yes. Notably, the Act defines an employer as including any individual partnership, association, corporation, LLC, business trust, employment and labor placement agency, and even includes the state of Illinois and local governments, as well as any agencies and political subdivisions thereof.
And Andy, how about employees? I know a question has just already come in asking about part-time versus full-time, and I know you'll address this here.
Yes, unfortunately, this law is all-encompassing, as you've already heard, and as you will hear more as we kind of dive down into the weeds of the statute. I mean, this is new frontier, not just for all of us in Illinois, but for employers around the country. Illinois is just the third state that has required this kind of leave. And the other two states are Nevada and Maine. So even my colleagues and clients in California are asking what is going on in Illinois. And hopefully, you take the bitter with the sweet. And today we're going to talk about some of the bitter things on our menu. And to go directly to that question from the audience, yes, part-time employees are covered. There is no exemption based on number of work hours, although Madeline will talk later in the program about how part-time employees don't necessarily receive a full allotment of paid leave. But in fact, the statute itself says seasonal employees, part-time, full-time, are all potentially covered. The other thing that I think a lot of employers and even individuals may not want to hear is that this covers employers of day or temporary laborers, even nannies. If you have a full-time nanny, gardener, housekeeper in your employ, they are eligible for paid leave. And so it's really important to look at the details of your engagement and relationship with anyone who works in your household. And we can refer you back to our earlier luncheons where we talked about the risks of being too aggressive for independent contractors. What Madeline and I want to make sure that you take away from this luncheon, along with some other things, is don't view this as a race to reclassify people as independent contractors to get out from under the clutches of this law. The perils of doing so remain in full force, just as we explained a few luncheons ago. Now, there are a very small number of employees who are not covered, and I'm going to go through a kind of a very quick recital of who these people are, because frankly, the exceptions for at least most of the KH client base really don't apply to day-to-day for-profit businesses. If you're an employee under the Federal Railroad Unemployment Insurance Act, you're not covered. Same thing for school district or park district employees. College or university students providing temporary services for their college or university are not covered, as are short-term employees of institutions of higher education. And then there's a limited carve-out for unionized employees who are subject to various terms under their collective bargaining agreements. And these exceptions extend to the construction industry, delivery, pickup, and certain state agency employees who are working under a bona fide bargaining agreement that presumably provides for paid leave at a minimum comparable to what is required for non-unionized workforces in Illinois.
So Andy, what if an employer already provides paid leave?
If you already provide paid leave, but you don't provide the minimum required by the statute, you must add more. So just because you may have a PTO policy or a vacation policy or some other leave, if it's not at least as beneficial as what we're talking about today, time to scrap it and bring it into the new era in Illinois.
So Madeline, can you tell us how accrual works under this new act?
Yeah, sure. I think there was actually a question on this, and we'll go over the rate at a good few times. So don't worry if you miss it once. I'm sure it'll pop up again. So for every 12-month period worked, an employee is now in Illinois entitled to receive paid lead time based on a number of hours worked at a rate of 1 hour of paid leave that they earn for every 40 hours they work. And this is up to a maximum of 40 hours of reserved paid leave for a 12-month period that employers are required to, at the very least, provide their employees with 40 hours of paid leave for every 12-month period. And over at Kelleher and Holland here, we call this the accrual method. So while a full-time worker will likely accrue the full 40 hours throughout the 12-month period, a part-time worker might not, and rather will likely have accrued fewer than 40 hours of paid leave. And it's really just based off of the numbers of hours the employee worked, as Andy was talking about a little earlier. And so a nice little quick example, the employee A, here, we got it on our screen, works 15 hours per week and for 52 weeks per year. So employee A will accrue 19.5 hours of paid leave annually. So this is, as you can see on your screen, 15 hours of working per week for 52 weeks is 780 hours worked that, per year for that year. And that 780 hours, if you take that and you divide it by the accrual rate of 40 hours worked for every 1 hour of paid leave earned, that leaves you with 19.5 hours of earned paid leave. And Additionally, the employees who are exempt from the overtime requirements of the Federal Fair Labor Standards Act are generally deemed to work 40 hours in each work week for purposes of paid leave. You know, time accrual if they really regularly work that 40 hours a week. If they, an exempt employee's regular work week is less than 40 hours per week, then their paid time leave accrues based on the number of hours in their regular work week.
So Madeline, can an employer choose to provide more paid leave, or can they provide paid leave at a different rate than provided under the Act?
Right. Okay. So yes, we now know that the Act requires that accrued time must be provided at a rate of 1 hour of paid leave for every 40 hours worked. However, this is, as just mentioned, this is a minimum requirement, meaning that the employer can choose to provide its employees with more than 40 hours of paid leave in a 12-month period. An example here, if an employer wants to provide its employees with 80 hours of paid leave per year, it can be, you can use an accrual rate at a rate of 2 hours of paid leave for every 40 hours worked, or for example, 1 hour of paid leave for every 20 hours worked, which in the end would both total 80 hours of paid leave per 12-month period. So it really doesn't matter as long as the rate of benefit is at least 1 hour of paid leave for every 40 hours worked. And the employer's paid leave policy follows the remaining requirements and provisions of the Act. So just as an employee can provide more paid work, they can also provide, the same 40 hours of paid leave per 12-month period in smaller proportional increments. So like there 0.025 hours of paid leave for every hour worked, which in the end would total 1 hour of paid leave for every 40 hours worked. It just really depends on how the employer wants to play it.
So when can these employees start accruing their paid leave?
Sure. So under the accrual method, every employee's paid leave begins accruing upon either the beginning of their employment, if they're employed after January 1st, 2024, or on January 1st, 2024, whichever is later. Okay, so we're going to go through a few examples. We see example 1 on the screen. Employee A has worked for their employer since 2019, but did not previously get paid leave. So employee A will begin accruing paid leave on January 1st, 2024. The second example on the screen, employee B has worked for their employer since 2019 and previously did receive paid leave. But again, employee B will begin accruing paid leave on January 1st, 2024. And a third example, employee C, who begins employment after the effective date of the Act. So this guy over here is beginning his employment on July 1st, 2024. And that employee will then begin accruing paid leave on the first day of their employment, so July 1st, 2024. Just so you guys know, we will use these three examples a few more times in this presentation. So just as a heads up.
So now we know how they start accruing, but how can employees start actually using their paid leave?
Okay, so then after the Act takes effect, I'll repeat it, January 1st, 2024, every employee will be entitled to begin using their accrued earned paid leave 90 days after either the commencement of their employment, after July 1st or January 1st, 2024, or 90 days after January 1st, 2024, if already employed. We'll do these examples again. Let's go through them, see how this works. Employee A, same thing as previously, worked for their employer since 2019, didn't get paid leave previously. They'll begin accruing the paid leave on January 1st, 2024, but they have to wait 90 days until March 31st, 2024 to actually begin using any of that accrued earned paid leave. Same thing with example 2 here. Employee B has to wait until March 31st, 2024, 90 days later. And then we got example C. Now, the employee began employment on July 1st, 2024. the employee begins accruing on the first day of employment, but has to wait 90 days until September 29th before using accrued paid leave. 90 days across the board.
So Andy, let's get back to you. Is an employee able to carry over any of this paid leave?
Well, yes and no. Let's talk about the accrual method. Yes, under the accrual method, where you earn your paid leave prorated over various time periods, as Madeline has described, employers must allow their employees to carry over unused paid leave from one 12-month period to the next 12-month period. However, you don't have to allow employees to accrue more than the 40-hour maximum under this statute. In this aspect, for any of you who are familiar with states such as California that currently prohibit use it or lose it vacation policies, it's a bit like the vacation accrual method in those states. So yes, if you opt for the accrual method, that is one of the, I think, potential negatives, is having to track that carryover and making sure you're properly accounting for when you're going to suspend new accruals based on the carryover.
So Andy, is an employer able to institute a longer accrual introductory period than that is under the Act?
Unfortunately not. The statute is very clear, as well as some additional guidance that's been issued by the Department of Labor in the last month. Paid leave must begin accruing no earlier than 90 days after the date of hire or 90 days after January 1, 2024, whichever date is later. If you want to put in a probationary period, for example, saying you can't use any vacation until you've worked here for 1 year for either accrual or use, that would be illegal under the Illinois paid leave law.
Madeline, do employers have any flexibility in designing the paid leave accrual period?
So yeah, there are already some employers that offer their employees paid leave using a different 12-month period start date other than, the first of the year. So common start dates would be the employee's work anniversary, the employer's fiscal year, maybe the employer's healthcare plan year. So that under the Act, the 12-month period may be any consecutive 12-month period designated by the employer in writing, either at the time of hire or upon notice to their employees prior to the change. So to use a different 12-month period rather than starting over at January 1st, 2024, there would be a few requirements. Obviously, the accrual period has to cover a full 12 months, consecutive months. The accrual rate, again, cannot be less than 1 hour of paid leave for every 40 hours worked. Third, the employer must provide written notice to its employees before January 1st, 2024. That's important, before January 1st, 2024, or at the time of hire, if after January 1st, 2024. That explains that the employer is using a different 12-month period for paid leave accrual than starting at January 1st. And lastly, the employer must provide its current employees with documentation of the balance of hours worked, the paid leave accrued already and taken, and the remaining paid leave balance at the time of notice of the change.
So Andy, does this mean an employer can no longer front load paid leave at the beginning of the year?
Amy, not at all. In fact, employers can continue to front loading paid leave if they do so for other current leave policies, such as PTO or vacation. And they can do it if they're doing this brand new under the paid leave law. Under the front loading method, employers can take the minimum 40 hours of annual paid leave and make it available to employees on the first day of employment or the first day of their 12-month annual accrual period. All employees, however, will still have a 90-day waiting period from January 1, 2024 or the first day of employment if hired in 2024 or later. In addition, under the front-loading method, as we call it, employers are not required to allow employees to carry over paid leave and may require employees to use or lose all of their paid leave prior to the end of the benefit period, or else they forfeit that unused paid leave. Employers who use the front-loading method must not forget to track the actual hours worked by each employee, because if, for example, a part-time employee would have received more paid leave under the accrual method, the employer must provide that additional time. And again, this would occur if you're front-loading something less than the 40-hour minimum based on a projected reduced workload.
So if an employer is using this front-loading method, are they able to designate a certain 12-month paid leave period?
Yes, I think if an employer wishes to use a different 12-month period other than the beginning of the calendar year under the front-loading method, the employer must meet similar requirements to those that were explained under the accrual method. Front-loading period must cover 12 consecutive months. The front-loaded paid leave must be at least 40 hours. And full disclosure, you're free to give more than 40 hours. Don't know why you would want to under this statute, but nothing prevents you from doing so. The employer must also provide written notice to its employees before January 1, 2024, or at the time of hire after January 1, 2024, explaining that the employer is using a specific 12-month period for paid leave, and the employer must provide its current employees with documentation of the balance of hours worked, the paid leave taken, and the remaining paid leave balance at the time of the notice of change. And this goes back to a point that we'll harp on again. You can't wait till January 1. There are certain things you're going to have to decide and do before the end of this year.
Madeline, so can employers set a minimum number of paid leave hours that an employee can use in a day?
So I think this is one of the questions that was asked in the Q&A. So while employees may determine when they use leave and how much they use or choose to use of their reserved earned sick leave or paid leave, employers can set a minimum leave increment of up to 2 hours per day. So in other words, an employer may require that if an employee uses any paid leave just for a single day, that the employee use at least 2 hours of the paid leave. So I'll give you an example. If an employee has a doctor's appointment, but really only needs 1 hour of paid leave, and the employer has set this minimum 2 hour increment, then the employee will use up the entire 2 hours of paid leave for the doctor appointment, whether or not the full 2 hours was actually used.
So how about any notice or record keeping requirements that an employer will have to do under this act?
Yeah, so written notice of the act's requirements must be posted in a quote unquote conspicuous place in the workplace and in the employee handbook if an employer has a handbook. And the notice has to include two things: the Illinois Department of Labor's existing notice regarding the act. They already have some preset language. And then, if applicable, a notice to the employees that they are responsible for paying their share of any health insurance to maintain coverage while on leave. Additionally, if an employer makes a change to its notification requirements for employees to actually request to use the paid leave, the employer must provide notice to its employees within 5 calendar days after making a change to this policy. Also, if the workforce contains any non-English speaking persons, the notice must be published in each of their native languages. All employers have to maintain records for each employee that show the number of hours worked, the number of paid leave hours accrued and taken, and the remaining balance. these records of how much has been used, earned, and worked have to be kept for 3 years and available for inspection by the Illinois Department of Labor. And if the employer does use the accrual method rather than the front-loading method, then they have to make sure that they keep it for 3 years for the employee to request to review the records.
So Andy, will employers be required to pay out any unused leave when an employee is terminated or resigns or retires?
Well, I'm going to give an answer that our clients hate to hear from a lawyer, and it depends. Okay. And let me kind of take a little deeper dive on that kind of, response. Under Illinois law, if you have a vacation policy, you are required to pay out unused and accrued vacation under Illinois wage and hour law and under the laws of several other states. But the paid leave law is a little different. And again, the outcome will be based on how you treat paid leave. If you treat paid leave as a discrete policy that is separate from your vacation policy, the answer is no, you don't have to pay it out on termination. Sections 15J and L of the new law are quite clear that this is not a mandatory payment upon termination, similar to vacation. However, if you bundle paid leave with your vacation, PTO policies, and use all of this time as one big account that employees can use, then yes, the paid leave accrual must be paid out on termination. What some of our clients are already doing, and I think if you can manage the administrative complications, it's a good idea, is let's assume you offer employees a 14-day vacation policy or 10 days vacation. What you could do is have a vacation policy of just 3 days and then a paid work leave policy, front-loaded, which might be easier to manage, of 7 days. And you set the policies up so there are different eligibility criteria. As you're learning, the Illinois paid leave can be taken with very little notice, if no notice at all. The employee enjoys great discretion on how and when they're going to use it. While vacation policies, in contrast, employers still can reserve certain parameters and controls on how it is used. You must apply for vacation by X number of days. Requests for vacation must be approved. And so this is a way to separate the two obligations, preserve the discretion you have over a traditional vacation policy, and this could be the biggest cost saver in all of this, reduce the payment of accrued vacation upon termination. So that is probably, the response that is, I think, I would recommend for many employers, again, if they and their HR record management, internal or external vendors are comfortable tracking this activity.
So Madeline, what about counties and cities that already have an ordinance regarding paid leave? Which law are the employers supposed to follow?
So I know we're running out of time, but there were a good few questions asked about, the Cook County ordinance, the City of Chicago ordinance, which one applies, which one do I have to follow, how does it work? So the Act, Illinois Paid Leave for All Workers Act, applies only to employers located in jurisdictions that have opted out of a local paid leave law or ordinance. So I'll read you the quick excerpt of the Act. So the provisions of this Act shall not apply to any employer that is covered by a municipal or county ordinance that is in effect on the effective date of this Act, that already requires employers to give any form of paid leave to their employees, including paid sick leave or paid leave. So For example, just as previously mentioned, Cook County already has its earned sick leave ordinance. And under the provisions of the act I just read, the Cook County ordinance would override the act, meaning that employers need only follow the obligations of the Cook County ordinance. So it's really extremely important to know whether or not your jurisdiction or what your local jurisdiction is, whether it be a city or a county, and know whether it already has a paid sick leave or general paid leave ordinance or any type of law in place. So very important for employers to confer with legal counsel to make sure that they're complying with the right paid leave laws, depending on the location of the business, and making sure that everything's going smoothly. These are big changes that are being made right now.
As you mentioned, we're running short of time, but real quick, if you could give us a recap of the consequences of non-compliance, Madeline.
So a few things. If that employee wants to allege a violation of the act, the employee can file a complaint with the Illinois Department of Labor within 3 years of the alleged violation. And the Illinois Department of Labor will generally refer such a violation claim to an administrative law judge for a formal hearing. Otherwise, employers that violate the act may also be subject to a civil suit by an affected employee for damages, including the amount of the actual underpayment, any other compensatory damages, and a penalty of $500 to $1,000. The employee can also recover appropriate equitable relief, as well as reasonable attorney's fees and expert witness fees. The very interesting thing about this is that employers will also be subject to a $2,500 civil penalty for each separate offense to be deposited into a special fund that was created in the state treasury and dedicated to enforcing the act. So there is a big fear right now that the Paid Leave for All Workers Act could evolve into a windfall for plaintiffs' lawyers and much like the current Illinois Biometric Privacy Act has.
So Andy, sum it up for us. If you can provide some key takeaways or doggy bag items for today's discussion.
Okay, happy to do that, Amy. And as those of you who've attended our prior lunches, you'll know that Madeline and I and KH in general, we're big fans of Winston Churchill. And so we always try to slip in a Churchill comment where we can. And what we've done on this slide is what Churchill would put on every memo that required action in World War II. Action this day with an exclamation point, also known as your doggy bag takeaways. And you'll see at the bottom, December 31, 2023. I'm going to pivot that up top and say by December 15, 2023, you will commit to do the following. Review your existing leave and vacation policies to make sure you have a holistic strategy that not only complies with, but takes advantage of whatever protections employers can reserve under the Paid Leave Act, which we call PLAWA here, kind of an awkward sounding acronym. If it applies to your business, if you've got employees in Chicago, Cook County versus Lake County, DuPage County that don't have paid sick leave laws, decide how you're going to address them in your employee materials and handbooks. Are you simply going to default to a highest common denominator or have separate policies? Right now, I probably would lean on the side of separate policies, but that ultimate answer is going to be based on the resources available to each employer internally to track this leave. The other key decision to be made before December 15 this year, decide whether to keep paid leave separate from vacation PTO to reduce termination payouts and to allow discretion over the use of vacation time, or simply to combine them into one big account to make it easier to manage. You also have to decide by December 15, how will your paid leave be earned? Accrual versus front load versus, and we haven't talked a lot about this, but here's an option, hybrid. you are allowed to decide, yes, our salaried exempt employees, for example, are all going to be front loaded, but the following positions, non-exempt, will be accrual, or part-time will be accrual, full-time will be front loaded. So there's a strategy there. Make sure you think about it and make a decision by mid-December. Then finally, prepare and distribute your mandatory written notices of paid leave rights to all employees, making sure non-English speakers have it in their native language and that it is properly published on websites, break room bulletin boards, and in your handbook. Again, no later than December 31, but please do it by December 15 so you can enjoy your holiday season. We've already addressed several questions that have come in. We're sensitive to the amount of your time. We'll take a couple more questions, but by all means, if we didn't address your question today, send them to us by email. You can write to Amy or your favorite KH lawyer, and Madeline and I will get back to you with our responses.
Sure will.
Thank
We
you,
look forward to
panelists.
hearing.
That was extremely comprehensive, and I hope it answered many of your questions. I see we do have a few more, and maybe we can squeeze a couple in before we sign off today. And anyone that we don't get a chance to follow up with live here, we will follow up with you immediately after our presentation here today. So let's look at a few of these. And by the way, we will be emailing copies of the deck to you once the presentation is over. So I know that was a question. How about this question? Can a manager deny a request if all staff are asking for the same time off?
So
Well, I'm
there's
going to jump.
Go ahead.
I'll jump in here, Madeline, and please chime in because these are uncharted waters. The Paid Leave Act makes clear that this is a bit like family medical leave, where if there's an emergent reason for paid leave, you get to use it and take it. It doesn't, in certain scenarios, it's the employee should try to ask maybe within 7 days of a planned paid leave. But if it's for an emergent reason, you may be out of luck and you'll have to sift between a vacation request that might fall under your vacation policy versus I am going into the hospital or my spouse has an unplanned emergency medical situation. I need time off, in which case that emergent reason takes priority. And yes, you could be in a situation where you have lots of people off work at one time. We'll see if the state provides some further guidance on that, but it's not there yet.
Another question that came in, is there an exception for teenagers that work for you?
Andy, I think you went over the exceptions. Do you have an answer to this one?
My response would be no. There's no age cutoff. There's no carve out for minor employment. Unless you're an educational institution and you've got temporary student workers, the very fact that they carve out temporary student workers at a college, I'm calling it for higher institution, doesn't mean a teenage worker at a fast food restaurant is denied their rights. So right now, assume that there is no difference in application based on age of your employee.
And we'll try to take one more here. Does this apply to employees working under the H-2A program?
So that is a question that we would probably have to look a little bit more into. Again, these are uncharted territories, uncharted waters. There's a lot of questions. There's also a lot of confusion about some of the provisions of the act itself, how current front loading or current paid time off that's already being paid, how is that going to stop and then continue? Do we have to pay that and then restart? There's just a lot of questions, and that's one of those that we can definitely look into for you and give you a response via email.
For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher & Holland's Employment Law Lunch and Learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.